Live. We are officially live on StreamYard, gentlemen.
Back to you in 5, 4, 3, 2.
And we are back, folks, here on the Michigan Insider on Sports Talk 1050, WTKA, online at WTK.com. Sam Webb, Ira Weintraub, live on location, Grand Traverse Resort and Spa, our annual trek. I call it a pilgrimage. We make our way north. It's our time to take in the fall colors, the beautiful Grand Traverse Resort and Spa. We do at least one road game a year up here, and we have Ms. with us. We also have our legal expert and insider, and fittingly so, Joe Simon, with us as well. Joe, good morning. How are you, my friend?
Good morning, Sam. Really good to be with you. Been looking forward to this. I told Ira earlier in the week, I don't think I've had this much listener outreach since one of the Ohio State breakdowns you and I did some years ago. And I'm going to try to take a deep dive, answer everyone's questions, and go through the convergence of the sports and the law.
Yeah, so let's have a little background before we get to the tunnel ambush. I'm calling it ambush. I'm calling it an assault.
All right.
Right, but whether it's Myles Garrett on the field, I guess it's a couple years ago now, swinging his helmet for the Cleveland Browns. You also had in the offseason, it was the preseason where there was a practice between the Colts and the Rams, and I think it was the Colts. Anyway, you had Aaron Donald swinging his helmet at an individual. One happened in a game, one happened in practice. There was a punishment from the NFL for the game. They didn't punish Aaron Donald because it was practice, CBA. You couldn't do it. No criminal charges in either case, right? And so there's this line of thinking, and you can tell me if it's right, that it's part of it. It's in the game. It does not count as a criminal offense because it's on the field of play, so to speak. Is there any accuracy to that? Can you be charged with a criminal offense for something that happens on the field of play? Let's just start there with that question.
I think you can, but it is a distinction, and I think a fair distinction, to talk about things that happen on the field of play versus elsewhere. And here's why, Sam. There's a doctrine in the law called implied consent. And for example, back in the day when cleats were metal cleats and a base stealer came in spikes up to second base, if that person slashed somebody or injured somebody, there's sort of this implied consent that's part of it, that by being on the field of play, you consent to certain things, some expected, some foreseeable. Going beyond that realm of expectation, I think, can invoke criminal liability. It's rarer there because players kind of feel like, hey, skirmishes happen, that's foreseeable. But as we're going to see in a minute, the use of an ordinary object as a weapon is a tremendous difference maker in the law.
All right. So if I'm on the field, I have my helmet off, and someone comes and swings his helmet at me, it's conceivable that could be a criminal offense.
Oh, I absolutely think so. Absolutely. Because not only the elements of your greater vulnerability, but because you're more vulnerable and someone is using an object to swing at you, that infers an intent to injure and to harm.
All right.
And we're going to learn about that too in a minute.
All right. So the reason why I set all that up is because even if there was some sort of legal protection, within the field of play, right? What happened after the Michigan State game wasn't on the field of play anymore, Joe. I mean, they were in the tunnel. The game is over. This implied consent that you're talking about would seem to me to be null and void. It doesn't apply. It doesn't factor in here anymore. Am I out of line?
No, you're exactly right. I think the expectation is that when you're off the field and going up the tunnel, there's no combat. There's no agreement, if you will, implied or express, that there's going to be combat.
All right. So calling it an assault.
Yeah.
Jim Harbaugh called it an assault.
Yeah.
I've been calling it an assault all weekend. Others are calling it a scuffle, a skirmish, a fight. This is one of those things that happens. No, you've had lawyers hired. You have the police, local authorities looking into it. Seems to me this is more serious than some folks are are willing to acknowledge.
Well, we're going to go right into the definition of what an assault is, the different grades, or if you will, a ladder of offenses in terms of severity. And I think once we do that, you're going to learn that, yeah, this absolutely could be actionable assault. Not only actionable assault, but maybe very on the more serious rungs of the ladder, if you will.
All right. So kind of walk me through, Joe. Is there a distinction between the players who are punching and kicking Jaden McBurrows and the incident that happened with Jamon Green, where a player is clearly swinging his helmet at him? Are these two different?
Yes and no. So both are arguably assaultive conduct. Both, an argument could be made as to what the level of intention is with respect to the level of assault charge that could come. But one involves the use of an article potentially used as a dangerous weapon, and that's the distinguishing factor there.
All right. And so I would, you have legal jeopardy and you have civil jeopardy
Right.
here at play, right? So kind of give me the threshold. What's the threshold that has to be met for it to be criminal assault?
For a criminal charge, a prosecutor has to believe they can prove their case beyond reasonable doubt. They have to have a good faith belief in doing that. And we're going to go through some of the elements in just a second, and people can make their own conclusions as to whether that could be true based on what we see. And then on the civil realm, you have like two different doctrines at play. You have something called intentional torts, where somebody is suing somebody for their intentional conduct. And then there's the doctrine of negligence, or if legal duty is imposed, failure to supervise, failure to protect. And that's going to be interesting too. And that's on a lower standard of proof. And, what's really going to be way interesting, and this is something that's going to blow my own mind, is, there's some litigation right now for players trying to argue that they should be classified as employees. And Sam, if that were to go through, just imagine this: there's a doctrine in law called respondeat superior, where that increases the liability for the employer to supervise their agency, their employees. So that could get wild.
All right. And so let's kind of start walking me through the different,
Yep.
Because I don't know all the legal sort of steps and all the legal requirements that have to be met to make all of these cases. And then also, as far as culpability, as far as liability is concerned, is it just the players in question, or could Michigan State be in jeopardy here as well?
The criminal law generally imposes liability on the actor, not on a supervisor or something like that. So we're going to actually walk through the ladder of offenses for those who are able to see us online. They can follow through, and I'll also try to do my very best to make sure that we know that not everyone can see. The bottom rung of the ladder, Sam, is something called simple assault, and it's not really simple. I put that in quotes because it's the base offense. In other words, each offense of assault is distinguished by added elements. So the base offense we commonly call simple assault or simple assault and battery. An assault is the offer of physical force or violence to another person. It does not have to be a touching. The battery is the harmful or offensive touching of another person. And we're going to walk through. So that was just exactly what I just explained, but I wanted what folks might be interested in. A battery is defined as a forceful, violent, or offensive touching of the person or something closely connected with the person of another. It's got to be an intended touching, not accidental. A lot of times people will say, well, how do you prove intent? Intent, Sam, is derived from inference, from the conduct, from the language, from the behavior. And one of the things about the concerted action, multiple people being involved, that is something really to be used in terms of making inference of an intent to harm. That offense, if someone were to be convicted, has a maximum punishment of up to 93 days in jail. It is a misdemeanor, and you can be subject to up to 2 years probation. That is simple assault. Let's walk up the ladder, and I think people are going to be starting to think, how do these all apply? The next walk up the ladder is aggravated assault. And each one of these steps up the ladder, Sam, is adding an element. This is where you have simple assault and battery, plus a serious injury. And what is a serious injury? It's pretty broadly defined. A physical injury that requires immediate medical treatment or that causes disfigurement, impairment of health, or impairment of a part of the body. I'm going to make a lot of statements just on things we've heard. I don't know the status of the investigation. Would a broken nose qualify? Yes. Would a concussion qualify? Yes. Would some other disfigurement, note that word, somebody got a scar, something like that? Yes, those qualify.
All right.
That is a misdemeanor with a maximum 1 year penalty and up to 2 years probation as well. 1 year meaning up to 1 year in jail, maximum sentence. Now here's the one that's really going to kind of, I think, be at play. We have something called felonious assault. It's really called assault with a dangerous weapon. The reason we call it felonious assault, Sam, is the first felony on the rung up the ladder, right? So we go from misdemeanor to felonies. This is the one many people have been asking about. This is the assault plus the use of a dangerous weapon. Injury is not a necessary element. And this is what I really want folks to focus on. The law tells us that some objects, guns, knives, they're clearly dangerous weapons inherently. But the law also states other objects that are designed for peaceful purposes, but they may be used as dangerous weapons. The way an object is used or intended to be used in an assault determines whether or not it is a dangerous weapon. And if somebody uses an object in a way that was likely to cause serious physical injury or death, that makes it a dangerous weapon. And Sam, that really goes to your original question on the field and off about use of a helmet. So this is a protective piece of equipment designed for protecting players on the football field.
Mm-hmm.
But the way in which it was used here and the number of times we saw strikes, the character of the use of the object can make it a dangerous weapon. And that is a felony offense. With a maximum penalty of up to 4 years in prison. Sorry, had a little tech difficulty. With a maximum penalty of up to 4 years in prison, Sam, at up to 5 years probation. So that's where we enter the felony realm. One more rung up the ladder for relevance, I think, for our discussion, which is something called assault with intent to commit great bodily harm. Remember, we're adding elements. This one does not require the use of a weapon, but this is an intent to cause great bodily harm. What does that mean? It means that in the action itself, somebody desired to cause great bodily harm. Actual injury isn't necessary, but here's the key. If there was an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. So, Sam, if you have multiple injuries because of a severe beating, that is an inference that that was the intended conduct, right? And this is a pretty broad definition. Any physical injury that could cause serious harm to the health or function of the body is included in the definition. Sam, this is a 10-year felony.
Wow.
Up to 10 years in prison is the maximum penalty. Now, let's try to apply that to the questions I've been getting and to other things. Well, what about a bunch of guys essentially curb stopping a player? Now, again, we don't know all the facts, but I'm going through, try to answer questions I've been asked. If you have people in concert acting that way, could you make the argument, Counselor Webb, that that is an intent to cause great bodily harm? Let's not talk about the helmet incident. Could you say that a bunch of people acting in concert, a pretty defenseless player prone on the ground, or what if that player was in fact dragged into that little hallway? Could you make that argument?
So could they make the argument that he threatened them in some kind of way?
Great.
To threaten them either verbally, or and maybe it was just a verb, but they felt that they had to protect them, even if it was 5 of them. they felt that he took a threatening posture towards them.
Generally, mere words do not allow the privilege of the exercise of self-defense. But words can be a player if they are words of threat that someone could reasonably perceive they need to act to protect themselves, or if they're words of consent. So in other words, you and I are arguing, right? We're arguing Buckeyes and we're arguing Wolverines or something that's deeply spirited. And we say, let's go outside. You say, all right, I'm in. Those are words of consent. And that you can consent to an assault offense. In Michigan, the only thing you can't consent to in an assault category is murder, which is the whole Jack Kevorkian thing. We're not going to talk about that, but that's why you can't do that. That's why that was able to be prosecuted. But you can consent to an assault offense, even if it came out bad for you. Even if the Flint side came out of Sam and it came out bad for me, if I consented, well, that's too bad for me. So words of consent, words of threat can invoke two different privileges: the privilege to act through consent and the privilege to act in self-defense. However, each has limitations. You can't exceed the scope. So if the threat is repelled, right? Let's say there is a words of threat that started the things in motion. Threat's repelled, but people keep going.
All right, so how about this? I'm not a part of the initial assault, but I see you, Joe, push my guy. You pushed my guy, and then I came in as to intervene. I came in to protect because I saw you take a physical action. Do I have some protection at that point, saying that, hey, I see someone under a perceived threat, and I intervene to help mitigate that threat?
Yes, we call that in the law the defense of others. The same privilege that you have to defend yourself, you can exercise to defend another. Yes, if that threat's real. And again, the same scope and the same of the privilege applies. Now, the one thing about self-defense, it's a twofold test in Michigan. You have to have both an honest and reasonable belief of harm. Honest meaning subjective to the person exercising the privilege. It's got to be legit, and then reasonable to the common person on an objective standard on how they choose to exercise the privilege.
Gotcha. All right, we need to you just unloaded a lot.
I did.
You unpacked a lot, Joe Simon.
Brought my A game today.
Yes, you did bring your A game, and what it really reveals is, I mean, these guys, these Spartans, these Spartan offenders, they have some serious. It's a criminal issue that they face, and definitely, obviously, some real civil issues. And I guess I do kind of wonder. That's kind of how it goes typically. Yeah, you sue the offender civilly, but you also often sue who they're representing as well. But you're saying that doesn't necessarily apply here?
I'm saying that it's going to be interesting to see the theory of liability there. So if it's not an intentional tort, right? So suing somebody for their assaultive conduct, then you have to have a theory of negligence, and the heart of that theory is that there is a duty that was violated. So the argument would have to be that a duty was owed by the Michigan State coach and personnel to supervise and bring their players in an orderly fashion, and the duty was breached. That's going to be an interesting.
What about the Michigan State representative that was there for the fight and was seen running away from it as not the assault, and then was seen running away from it as it was being
There were two offensive things about that. Number one, yes, I think that might be a breach of duty. And number two, I think we got to get Ron Warhurst on the line, because that form running, Sam, was suspect, very suspect. But yes, no, in all seriousness, right. I mean, if you have a duty, like a parent to child, or a coach to player, or a supervisor of football operations, or whatever the title was, that was breached, yeah, I think that's totally fair game.
Absolutely. All right, we need to get to a break, folks. A lot of great info with Joe. We got some actual game stuff to talk about too. And he's gonna be with us all weekend up here at Grand Traverse Resort and Spa. More to come here from GTR, so stay tuned to the Michigan Insider on Sports Talk 1050 WTKA, The Ticket.
All clear.
All right. So I have got to. Let's see.
this is why we.
Joe, this is why we bring you on. Of course, we're still on the stream. We
Yeah,
should,
we're still live on stream. I was
You're
going to
still
say,
live on the video, of course. And
Oh, I
I'm
can't
here.
see the questions. Can I end my presentation?
No, I just
Because I can't see the questions.
we just have some comments coming in so far. I can scroll through the comments, but this is why we brought you on, because people obviously wanted to have you on to go through all this. So I'll just kind of scroll through the comments, Joe. You can see them on your screen.
I
Are you-
can't unless I minimize this.
It'll screw up that screen. Don't do that.
Don't do that.
Don't do that. Bring that back up. It would seem the criminal legal action will be coming, but what about civil action? Can MSU be held responsible for these actions?
Yeah,
The
we
injured
just
will
did that
clearly
one.
Go. Oh, you did that one.
Yeah.
Next one, Sam.
Yeah, when will the Big Ten make a statement? It must be punishment for Mel Tucker. The buck stops with him. Toxic culture.
You know, I don't know that we want to talk about this on air or not, but we're still streaming. We have right now a lot of political discourse on words of incitement, and people should be held accountable. It's going to be interesting to see if that's a player here too. I mean, if job one at Michigan State is to hate Michigan and job two is to beat Michigan, you know, that's a player, I think. I do.
All right. Here's another one. Hey, Joe. So when can we expect to hear from the police or authorities regarding the charges? Is Jaden represented by an attorney? I haven't heard that, as a matter of fact.
That's a good one to ask me on air about the process and what we can expect to hear.
Okay. Yeah. I don't know if they're watching this, but I'm pretty sure they have an idea that they are in there's some serious legal jeopardy here.
oh no, I think this question that just popped in, Sam, is actually a good one that we can kind of stray away from everything and kind of have a little lightheartedness. Where
It's a very important question.
side question, Joe, how many yards do you think we'll have against Rutgers?
Passing or rushing? That's going to be the question.
Let's go total. How about that?
Oof, I don't know.
More first downs,
Yeah.
Rutgers. Oh, sorry,
Yeah.
more first downs for Rutgers or punts for Rutgers.
You know, this is one of the things I will be talking about tomorrow. So I'll leave a teaser.
Oh, there you go. 3:30 tomorrow. Actually, well, Joe, you'll be on about what, 5:30?
5:30, yeah.
There we go.
Yeah. Oh, 5:15 actually.
And he said rushing yards.
Ah.
He was specific. He said rushing yards.
We'll talk about it tomorrow. Leave it as a teaser.
I sent you one more message.
Okay.
I don't know if you want to answer this on or ask me this on air, but people have been asking about Michigan's potential liability. Do you want
Really?
to go? So again, you got notice, right? Franklin 2 weeks earlier says there's going to be an incident. You have security in place that wasn't that and does a property owner have the duty to protect the persons on the property? So I don't know if I want to talk about that or not, but that's a possibility.
Yeah, I mean, I guess it's a question. It's not one that even dawned on me, because you're looking at 100 years, close to 100 years of handling the tunnel a certain way. I don't care that James Franklin said something the week before.
That's notice, though. So if you slipped on the floor right there last week, and you say you got a bad spot there on the floor to Grand Traverse, and they didn't do much about it, and I slip and I hurt myself, there's notice.
So, but my follow-up question would be, the notice is that something happened at halftime when the two teams are in the tunnel together.
That's right.
And they're completely separate incidences, and they're completely unrelated, really.
I think it's a distinction, but maybe not a distinction without liability. The weird thing about this is that would have to probably be a Michigan player bringing the action against Michigan. So again, listen, we're off air still.
Yeah, we're still off.
All right,
We're on
people
stream
can
now.
hear me, but they'll enjoy this comment. Listen, the when there's blood in the water, the sharks come.
Yeah, I asked this question
they'll
already.
sue everybody they can.
Yeah, see, someone they're asking the question that I just asked you on the air is it likely that MSU will have civil liability here? And it sounds like you don't think so.
I
Open playing
think
in
they're
1
going to
minute.
be sued 100 million
1 minute,
%,
guys.
because that's the deep pocket. The theory of the liability will be interesting, and yeah, I think it's there, especially with the football ops guy running away. because you got to find the duty first, right? You have to find that a duty was breached. Well, what happened?
Can Mel Tucker be held liable in court for only scoring 7 points?
Oof.
Well, I don't know because
not in court.
I don't know because he hasn't arrived yet.
The court of public opinion.
We're still waiting for him to show up. He's still coming, I guess.
No, he's running.
Oh,
He's running.
okay, gotcha.
Maybe he could be sued for his for a refund for the.
So you want to segue to the game here, or you want
Up to you, whatever you guys want to do.
I'll ask the Michigan liability question because all these questions.
There was one other one that somebody asked. Oh, the process. The process.
Okay,
that's right.
Yeah, everything else we covered already.
Back to you in 5, 4, 3, 2.
And we are back, folks, here on the Michigan Insider, Sports Talk 1050, WTKA, online at WTK.com, live on location at Grand Traverse Resort and Spa with our legal expert and insider, Joe Simon, talking about what I've been calling an assault, what Jim Harbaugh is calling assault, what the victims clearly believe is an assault. They're already bringing lawsuits. And so very clear from your opening statement, Joe, that there's some exposure here for those Spartans. Maybe not for Michigan State as much.
Well, they're going to be sued for sure. And the theory of liability is what I'm interested to see. But yeah, they're going to be brought into it for sure. Absolutely.
All right. So is there, I ask on one hand, is there any exposure for Michigan State? Any exposure to Michigan here?
I've been getting this question a lot this week, Sam, and I think potentially yes. Now, listen, I'm not saying that's what I want to happen, obviously, but there's a doctrine in the law that says a couple doctrines. One, as the owner of a premises, you have a duty to protect, though you make a safe environment, essentially, for those who come upon it. It's called premises liability. The other thing is that you have notice, arguably, that was made by James Franklin, who says a couple weeks earlier, hey, you're going to have an incident in this tunnel. So just like if a premises owner has notice of a slippery floor, if they don't remedy the slippery floor and somebody falls and hurts themselves, that notice can be a big element of the premises liability action. Similarly, an argument can be made here. The weird thing about that, Sam, is it seems like a Michigan player would have to be making the argument against Michigan.
Yeah, and I don't anticipate that happening. But at any rate, here's a process question, Joe. When can we expect to hear from the police or authorities regarding charges on this?
Yeah, nothing yet. In an investigation, there's nothing that's subject to the Freedom of Information Act because that's an exclusion. The case is still under investigation. When the investigation concludes, we'll be able to get it by Freedom of Information Act, but then it'll be turned over to the prosecutor's office for review for a charging decision. A prosecutor can charge a case, can not charge a case, or can send it back for further investigation. So those are the three options for the prosecutor, but I don't think we're going to get any of the details that so many of us are curious about until that investigation's concluded. And then we'll get player statements. We'll hear what's on the other side. You know, did somebody say something? Was there a little brother comment? Now, let me be clear to the point we made earlier. Flapping your jaws like that is not justify an assault. It has to be words of threat or words of consent that rise to the level of somebody's invoking one of those two privileges.
Is false advertising a crime? I mean, is that a crime, Joe? I mean, if you can't put something on a label that isn't actually in it, not one of the ingredients, right? You can't do that, can you? You can't falsely advertise, can you?
That'd be a violation of the Consumer Protection Act.
All right, and so Luca asks a very clear question. Can Tucker be held liable for saying he's coming and not actually coming, Joe? I mean, this is a question that just came through via YouTube, man.
Well, there's a few bad jokes that hit my head when I read that question. I'm going to leave that be.
There was a game,
yeah,
Joe Simon. There was a game that was played, one in which Michigan imposed its will in the second half of that game and sort of emphatically put Michigan State down. You had some takes heading into that game, or some questions heading into that game. Here's what your big takeaways were from it.
Like many, our red zone issues are of concern, and also our passing. We're 8 games in, 2/3 of the season, and Sam, I'm developing a small, not theory, less than that, a small hypothesis, because it's not just the passing statistics. It's the routes that we're running, or I'm going to say it a different way: the lack of routes we're running. We are pretty doggone simplistic in our passing game. There are the higher end throws in our games have been like 1 or 2. And that's really, especially in the red zone. I'm gonna flat out say, especially in the red zone. Slants, rubs, backline routes. Haven't seen that except a couple of times. I'm wondering if there's a trust issue or an arm issue we don't really know about that's causing that. I don't have any information. It's just a speculation on my part, but that's the thing that's concerning me, because that, I believe, is what's limiting our passing game, and a lot of hungry receivers still not yet being fully enveloped. That's I believe it is the plays that we are calling that are limited.
Yeah, I think it's more. I think it's more about approach. There's no sign of physical issues with JJ. No sign, no signal at all. I can only think that they're leaning into what they think is their strength and is what is going to lead to success. Now, is that enough to win a championship though?
I don't think so.
Is that enough to beat the top 5 teams or top 4 teams in college football? Is that enough to win on the road in Columbus?
I don't think so.
That'll be the test. And if it is, or if they think it is, then I think what that signals is that the depth of your receiver room is going to look different. You always have 8, 9, 10 receivers, but you won't always have half of them being All-Americans, right? It just the day and age of those kinds of guys kind of sitting and waiting in the transfer portal era. That's hard to sustain. I think impossible to sustain. But and I'm not saying that to be an alarmist. It'll just be interesting to note the approach and the success of the approach if this is what they are. I'm not saying that it is. I mean, have they evolved or are they still evolving? That's the question I asked earlier.
Sam, this is the fight that I've been having with my kind of football buddies all week. I'm not buying that this is leaning into their style. I'm just going to come flat out and say, I don't buy it. We believed coming in, for good reason, and especially if the quarterback position was settled, the ceiling was going to be much higher. With receivers we thought had elite capability across the board, and with a quarterback who had a skill set that we thought was far better than just launching a ball deep. Mm-hmm. I believe when Jim Harbaugh said in the spring, we're scary good, even though JJ wasn't really participating fully in the spring, that he was talking about something beyond what we had last year. I believe that it was an expansion. Sam, I'm not buying it's just a style thing. There's something here that just doesn't hit my football eye the right way.
It's not JJ's health.
I hope that's so.
It's not that.
Then it's time. It's time to let it go. I've been saying, I'm laughing because I've been saying that for 3 weeks, 4. I don't know. It's time to let it go and put it on display and game rep it. And I'm talking about everything, all the throws. We believe we have a quarterback capable of making all the throws, and he needs to make them in game action because, yes, I think we're going to need to score lots of points in multiple ways in Columbus and beyond, hopefully. I absolutely think that's going to be necessary.
Yeah, I think so too. But, time will tell. Here's the big question, because they clearly have the weapons. Mm-hmm. The guys in the arsenal, they have the trigger man. Can you dial it up when you need it if you haven't repped it?
I do not like that recipe. Can you do it? Yes, but I don't like it.
Well, and that's why these next 2 games are really important.
Yeah.
Rutgers is a, no disrespect intended, but it's a scout team they're about to play.
Well,
is it important in a game like this to, hey, you know what, we need to rep the passing game in preparation for what is going to be, I think, a pretty good Illinois defense. But again, a team in Ohio State that, you can probably going to be able to run the football on them like you ran it, but are you going to be able to pressure them like you pressured them last year? And if you can't, are they going to be able to put up more points? Probably. So that means you got to match. Can you match it just with the run? Or are you going to have to be more effective through the air? Can you pull that out when you need it if you haven't repped it?
You can, but it's a bad recipe. Why test that? And, Sam, Rutgers actually defended the run against us very well. Don't forget they have a good coach who's going to really load up to do that. Yeah, we're going to have to let it go. I think that's the right thing to do. And yes, I definitely think in the Illinois game, that's going to be a necessary component. Look, I just believe that it is a bad recipe. I was a little bit wrong about that, Sam, at Michigan State last year. You and I had this very discussion. We were not passing going to the Michigan State game very much last year. And I kept saying, well, if we're holding that back, it's bad to just go in one game. Although Cade had a hell of a time throwing the ball. We had a field day throwing, and that kind of worked. Yet, I don't think it's the right recipe. I think it's asking a lot to rev the engines only when it's the last game of the season or the last two games of the season.
Gotcha.
No, I'm not there. That's not me.
Gotcha. All right, Joe. Hey, man, it's great to have you up here. I mean, and you get some time with Lisa to kind of relax, right?
Yeah.
Kind of relax and have some time.
Yeah. Well, that was the original intent. We had a little event yesterday, but we're going to try to maximize that. I also have to say that we got to shout out Greg Dooley. Right before the break, I made the mistake of looking at his tweet. Good one, Dooley. You almost made me start laughing right on air, but I have to show you that when we get off. But I wish I hadn't done that. But, it's a beautiful place. We have a beautiful room. It's a great setting. The weather is incredible for November.
Isn't it?
And, I hope we get some Wolverines out here for tomorrow's countdown to kickoff right here. That'd be great.
Yeah, it's going to be a ton of fun. And don't forget, Wolverine Weekend, you can start getting signed up for it now, June 10th and the 11th. You can go to grandtraversresort.com. The year one was an absolute blast with J.J. McCarthy and Ryan Hayes and Ronnie Bell were the players that were a part of Wolverine Weekend. Devin Gardner, our Monday morning quarterback, was around. John Bacon was the keynote speaker. You can go to grandtraversresort.com right now and get signed up. Tell folks about the law offices of Joseph A. Simon.
You can find us at themichigandefenders.com. We are right across the street from Michigan Football Stadium. That's Joe's Garage, where we do the Victor's Lounge. But all criminal defense needs, anything from misdemeanor all the way up to felony. And as you see, there's a ladder of a tree, if you will, of offenses. Nobody ever expects they're going to need somebody like me, but that's where you can find us if the need arises.
I don't have the hot button, but it'll just pretend we can jam at Joe's Garage.
Way to slide that in there, Miz.
Nicely done, Miz.
Way to slide that in there. Hey, folks, as we get to a break, I want to remind you, if you have any home improvement needs, our friends at Chelsea Lumber, they're where you should go. They're your one-stop shop for your home improvement needs. Of course, they have the lumber you need. They're one of Michigan's oldest and largest lumber yards, of course, serving customers for over 100 years. But much more than that, all of the construction materials that you might need for whatever your home improvement project is, the cabinetry, pole barns, garages, tools, decks, doors, windows, paint, work clothes, boots, everything in between. You can find it at Chelsea Lumber, because Chelsea Lumber is where the home begins. They even have design help if you're renovating your kitchen, for instance. Even have design help to help you with that. And then once that design is put down and they come up with it for you, they'll even help you find a contractor if you need help with that as well. That is the Chelsea Lumber difference, with 3 locations to serve you in Chelsea, Saline, and Bridgewater. And also find them online at chelsealumber.com. Chelsea Lumber, where the home begins. Got to get to a break. Back on the other side here on the Michigan Insider, live from Grand Traverse Resort and Spa on Sports Talk 1050 WTK, The Ticket.
All clear.
This is what
All right.
Dooley.
All right. So
We're
I
talking
think
about the different
that's going to
assaults.
conclude the stream itself. So
Yeah.
so I'll end it right now. Thanks for coming. Thanks for